The government breached the plea agreement in two independent and material respects. It invoked a carve-out provision to escape a base offense level it deliberately agreed to, based on the conviction it had known about since the indictment was filed and expressly incorporated into the plea agreement itself. And it recommended a multi-count upward adjustment it had expressly told defense counsel would not apply. The government's opposition confirms both points while offering a newly discovered alternative theory, one conceitedly missed by everyone at sentencing, to paper over the prejudice its breaches caused.
In today's video, we'll be discussing how probation didn't know, the feds didn't know, Brick's lawyers didn't know, but people expected Bricc to know? This trip about to be crazy.
The government's opposition does not refute the breach, it confirms it. In attempting to defend its departure from the plea agreement's agreed sentencing framework, the government reveals three things. One, its invocation of the carve-out rested on a conviction listed on the face of the indictment and expressly incorporated it into the plea agreement itself. Two, its sentencing memorandum recommended a +2 multi-count upward adjustment under USSG 3D1.4. That is, its own pre-plea email expressly told defense counsel would not apply. And three, the analytical framework it now uses to justify a total offense level of 23, specifically 3D1.2D, grouping followed by 3D1.3B, aggregation, which applies nowhere in its sentencing memorandum and is, by the government's own admission, in a footnote, a theory, both the probation office and parties missed in the sentencing filings. Come on, son. The last concession is dispositive on prejudice. The government asked this court to find that Mr. Mitchell suffers no prejudice because a newly surfaced post hoc analytical path, one the government concedes no one had identified when sentencing filings were submitted, happens to reach the same number as the flawed calculation it actually presented to the court. But the prejudice inquiry does not ask whether the government can later reconstruct an alternative path to the same outcome. It asks whether Mr. Mitchell's decision to plead rested in significant degree on the government's representations and whether the government honored those representations as agreed to in plea agreement Sonabello versus New York. Mr. Mitchell pleaded guilty, understanding that his total offense level would be 19. The government told him so in writing before he signed. The plea agreement's carve-out was not designed and cannot reasonably be read to permit the government to retroactively reclassify a conviction it had in hand from the inception of the case. The government sentencing memorandum recommended a multi-count upward adjustment it had expressly represented would not apply. These are independent breaches. The government's opposition offers no genuine answer to either. The motion should be granted.
So they're saying y'all already knew about this shit. And y'all came up with the plea deal, we agreed to it, and we signed it. Not only did we sign it, probation agreed with it, y'all agreed with it, we agreed with it. So that's supposed to be good enough. And y'all broke your own plea deal in two different ways. That's like you coming home and saying, you know what? Shit, we supposed to do this right here. And the people in the house say, nah. We actually not going to do that even though we agreed to it. And you come out with two ways in which they agreed to do this shit and why it's supposed to still happen. You can't make this shit up, bro. So you mean to tell me y'all did all of that research, y'all already knew about all this shit, said the plea deal was good, we signed the plea deal, and then y'all say the plea deal is bad because y'all quote unquote missed something? Right. So you buy something and then later on they find out, it's actually worth more, bruh. So you should be paying me more.
No. If you ever wish payday came sooner, this might actually help. There's a banking app called Current with a bunch of useful features. And one of the main ones lets you access up to $750 of your paychecks early if you switch your payroll over. With Current, you get a full set of features like paycheck advance, fee-free overdraft, and the build card and more. There's everything in one app. I actually like that myself, which is why I partner with them. And right now, they're giving $75 to anyone who signs up using my link or scans the QR code on the screen. If you scan the QR code, it'll take you you straight to the sign-up page, or you can create your own account. Just go through the normal sign-up steps, enter information, order your card. After you complete those steps, you'll see the option pop up to enter my promo code, which unlocks the $75 bonus when you switch your direct deposit. So make sure you go through the full sign-up process so you don't miss it. If you ever feel like managing money is stressful and tight sometimes, it's definitely worth checking out because that's literally what it's designed for. Let's continue on, man. Government breached the plea agreement by recommending a multi-account upward adjustment contrary to its pre-plea representation. The government characterizes the July 17th email as a hedge estimate, unenforceable under bench, but the government simultaneously acknowledges in its opposition that the email's prediction about the multi-account adjustment has now proven correct, that no upward adjustment should have applied. Yet the government's own sentencing memorandum recommended exactly that, a +2 multi-account upward adjustment. The government now tells the court that its pre-plea representation was accurate and that its sentencing memorandum recommended the opposite. That is the breach. Not what the government says in its opposition, but what is submitted to this court. See, the government's reliance on United States versus Bench, I'm saying Bench because I don't want to ruin the damn name, is misplaced. Bench addressed the narrow question of whether the government was obligated to firmly advocate for a sentencing recommendation it had agreed to make, not merely recite it. It did not address whether a pre-plea representation about how the guidelines would be calculated, made in direct response to a question from defense counsel before the defendant signed, could form part of the inducement for the guilty plea. Under Sanabello, it can. When a plea rests in any significant degree on a promise or agreement of the prosecutor, such promise must be fulfilled. Meaning, if we signed it, you better honor this shit. Defense counsel asks how the plea agreement's multiple categories of conduct were grouped for guideline purposes and what the total offense level would be. The government answered the total offense level would be 19. There won't be an upward adjustment for multiple counts because the other counts are too low. Mr. Mitchell understood this and relied on it. Oh, that's crazy as hell. And signed it. It sentencing memorandum said the opposite. That discrepancy is not a matter of estimate versus promise. It is the material representation made to induce a plea, followed by conduct that contradicted it. The government argues that paragraph 28's integration clause forecloses reliance on the July 17th email, but the parole evidence rule does not bar extrinsic evidence offered to resolve an ambiguity in an existing term. Only evidence offered to add new terms to a fully integrated agreement. The July 17th email is not offered to add a new term. It is offered to show what both parties understood paragraph 12's grouping provisions to mean when Mr. Mitchell signed, specifically whether the multiple categories of conduct would generate a 3D 1.4 upward adjustment. That question is not a new promise imported from outside the agreement. It is a question about how the existing sentencing framework was understood to operate. Extrinsic evidence bearing on the mutual understanding is properly considered.
The defense is saying, bruh, we asked y'all about this shit before. We literally asked y'all about the grouping, and y'all said, nah, don't even worry about it. Don't trip. Don't worry about it. It's all good. It's all good to go. Here you go. And we go, you sure? Yeah, I'm sure. Because we talked about this shit, right? We did. It's good. All right, bruh. Bro, the feds, this is so foul. I don't know why the judge didn't say, nah, y'all messed up, bro. Go ahead. He good to go. Matter of fact, I'm gonna give him the lowest. The judge has to do this shit, bro. I don't see in what world the judge does it. But let's continue on.
Mr. Mitchell was prejudiced by the government's breach. Mr. Mitchell entered a plea agreement understanding that his total offense level would be 19, producing a guidelines range of approximately 57 to 71 months at criminal history category 5, or 63 to 78 months at category 6. The government now seeks 92 to 115 months, a range that more than 30 months above the top of what Mr. Mitchell understood he faced and roughly doubled the low end. That disparity is not theoretical. It flows directly from two independent breaches, the carve-out invocation that substituted BOL 20 for agreed BOL 14. on the spit shell cases count and a multi-account adjustment that contradicted the government's own pre-plea representation. The government argues that Mr. Mitchell suffered no prejudice because the plea agreement's substantial benefits, including count 1 dismissal, no fraud superseder, and the non-prosecution agreement remain intact. But Mr. Mitchell bargained for those benefits within a specific guidelines framework. Probably should have wrote that different, but all right. The government cannot strip him of the latter while pointing to the former and ask him to be sentenced as if he pleaded guilty to all 3 charges. Put simply, a breach is not excused because the breaching party honors some of its other obligations. The government also points to paragraph 27's acknowledgement that no one can make a binding prediction or promise regarding the sentence defendant will receive. But that provision addresses the ultimate sentence. The disposition the court imposes after considering all 18 U.S.C. 3553A factors, which, of course, the parties cannot know at the time of the plea agreement. Know at the time the plea agreement is signed. The provision does not authorize the government to recommend a guideline range materially inconsistent with its own pre-plea representations about how the guidelines would be calculated, nor does it authorize the government to now seek a different guidelines range that it agreed to when it made its initial offer to Mr. Mitchell. The government's agreed upon guidelines framework is not the same thing as the sentence in paragraph 27 does not swallow paragraph 12.
And they're basically showing how the plea agreement was for less. Talking 5 to 6, maybe 5 to 8, to now go from 10 to 12. And you had to show this to the judge because the judge has to see it as, yeah, that's a sweet deal. That's a really good deal. Feds, why the hell would y'all even give him this deal? And y'all didn't already had all this time on this indictment. Then you were asked about this specifically before signing, and you said, no, it was all good. And that's the issue that I'm having personally just reading this shit. I know some of y'all like, damn, bro, the feds can do that? Normally not. That's why we got Sonabello and shit, but damn.
The government's newly minted theory does not cure the breach. Bruh, that's talking shit. All right. The government's principal response on prejudice is that even using the plea agreement's own agreed BOLs without invoking the carve-out grouping followed by aggregation independently produces a total offense level of 23. This argument fails for 2 reasons that have nothing to do with whether the government's guidelines math is correct. Oh, they talking big shit. All right, the breach occurred when the sentencing memorandum was filed and could not be cured by a theory the government devised afterwards. What? All right, the framework appears nowhere in the government's sentencing memorandum. Instead, its sentencing memorandum adopted the probation office separate group methodology and recommended a +2 multi-count upward adjustment under 3D1.4, the opposite of what the government had told defense counsel would apply. The opposition now abandons that methodology entirely and substitute a new one, offered for the first time in response to Mr. Mitchell's breach motion. I don't know how to say that. Alcala Sanchez forecloses this maneuver directly. A breach is not cured by later mitigation because, one, really cannot calculate how the government's error in breach may have affected the perceptions of the sentencing judge. The breach is measured at the moment the government submitted a sentencing memorandum contradicting its own pre-plea representations, not at whatever moment the government identifies an alternative path to the same number. Whether or not 3D1.3b independently supports a total offense level of 23 is therefore beside the point. The government cannot retroactively cure a breach by showing a different analytical route, one it never presented to the court, would have arrived at the same destination. The principle extends even further than the government's opposition, acknowledges even an explicit on the record retraction of an erroneous recommendation before sentencing does not cure a plea agreement breach. At that late stage, the breach, however, inadvertent, cannot be undone. If walking back an erroneous recommendation in open court before sentencing is insufficient to cure the harm, the government's post-breach identification of an alternative analytical framework in opposition briefing is plainly insufficient as well. Meaning, hey, bro, y'all gonna make up new rules
try to enforce these new rules? Hell nah. Y'all already agreed to what we already said. The government's own concession defeats its prejudice argument. The government acknowledges in a footnote, what? Okay, that both the probation office and the parties missed this grouping rule in the sentencing filings. That concession is fatal to the government's prejudicial rebuttal. And the prejudice inquiry under Sanabello is backward looking. Did Mr. Mitchell's plea rest in significant degree on the government's representations? It did. The government told him his total offense level would be 19. The government sentencing memorandum sought 23 through a methodology it now concedes everyone had missed at the time. Mr. Mitchell could not have anticipated a framework that the government probation and defense counsel all failed to identify. Rather, he waived his trial rights, admitted to uncharged fraud conduct, and agreed to a blanket appellate waiver in reliance on representation the government walked away from and now seeks to impose years longer in custody based on a guideline range outside what it agreed to in the plea agreement, asking him to absorb the consequences of a calculation no one saw coming. One that never disclosed to him before he signed is precisely prejudice. Sanabello prohibits. The government's no prejudice argument depends entirely on a theory it concedes was invisible to everyone until after Mr. Mitchell's breach motion was filed. The government's alternative theory does not cure the breach. It compounds it.
They're just pointing out how these cats just made new rules, bro.
Remember when we was younger and we was playing basketball? That Euro step shit, that's new. We never did none of that shit. So it's like watching the damn game and going, oh shit, well, the Euro step is cool. And then everybody else like, nah, actually, no, the Euro step isn't cool. That's travel. The feds are dirty. And this is why I could never, ever, for the most part, ever just sit up here and take the feds at face value. We sat up here with Dirk. We sat up here with a bunch of cats. Hell, even the Pooh Shiesty shit, which we'll get to later on. Bruh, the feds are full of it. You can't tell me we're going to sign this deal and you had this paperwork for years and then try to make up new rules as you decide to proceed and then think that that's good enough. That's not, bruh. That damn near should be illegal because y'all basically said, oh no, we actually missed it, Judge. Come fix our shit. Yeah. Come fix up our shit, bro. Because if you fix up our shit, then basically it's going to make it all good. The judge can't agree to this. I don't know how the judge actively goes, you know what, man, this is a good thing right here. I'm going to go ahead and say you guys' mistake is perfectly fine. No, it's not. Your mistake is your mistake. In the way in which it's supposed to go, it ain't supposed to look nothing like this. So now, I don't know what happens. If the judge agrees to it, man, I don't know how people start looking at these plea deals, especially when it's a sweet deal like Bricc got, and go, yeah, let's just sign that shit. There's no way in hell you can do that. So I hate to say it this way, bruh, but if the feds pull this shit off, we're all screwed. We're all doomed. Because you may have a family member who had a bump in the road and they may talk to you and they go, damn cousin, damn brother, damn sister, damn mother, damn father, damn aunt, damn auntie, damn granddad, damn grandma. The feds are saying, for all this bullshit I did, I can get 3 years. And then you like, all right, 3 years, three freaking years. All right, that's not that bad, man. We thought you were fucked. And you go, I can't believe this shit either. I'm finna sign that damn thing first thing in the morning. And then you go look at your lawyers and you're like, yeah, all right, this shit cool. This shit good, man. This some good food right here. All right, man, listen, man. It is what it is. I fess up. I own up to my mistakes. And you sign it. And you telling your people, yeah, man, shit, it's going to be a long summer, but I only got 3 summers in the slammer. And as you get ready to come to court, the feds go, hey, we actually, my bad, bro. My bad, man. My bad. You know, the 3 summers, we actually gonna double that. You're gonna spend 6 summers in here. And then imagine everybody making fun of you for something that the feds didn't know at the time, your lawyers didn't know at the time, and probation didn't know at the time. And you're supposed to be the smartest one in the room. Man, listen, everybody ain't Ceddy Nash. I'm just going, let me stop that shit. Yeah, I hope the guy just don't, man, bro. I don't care who it was or what it is or anything like that, unless it's obviously, somebody with like grave injustices, like a Derek Chauvin or something like that. Like, man, I would have been in agreement with that. But on this one, nah, can't do it. Can't do this shit. But hey, y'all, let me know your thoughts on this one. What do you think is going to happen? Do you think the judges and the feds are so corrupted that they just going to say, F it, we going to rock with it? Or are you like me, like, brother judge, there's no way in hell that the judge can say this is cool? Or maybe you got a different theory. Maybe you got some shit that we need to see. Hell if I know. But let us know, man. Hit that like button like you like something if you can, man. 14K away from these 2 things giveaway. If you want it, easy. Like every video, comment on every video, share every video, and it's fine to go. But click right here to see how Fulio got his revenge through death, I guess. Click right here for that video, or click right here or right here for the playlist, and I'll catch you on the next one.